Week 5 on Mark Herrmann's The Curmudgeon's Guide to Practicing Law. Now let's get into how to do depositions. We'll split this up into how to defend depositions this week and how to take depositions next week. Defending depositions. Not all documents that are shown to witnesses are automatically discoverable. Only those that jogged the witness's memory. Be careful which documents you show your witnesses. Also, if someone asks what documents the witness was shown in preparing for the deposition, you can and should object to the question and instruct the witness not to answer. Which documents you choose to review with the witness constitutes work product and is not discoverable. If the lawyer then thinks to ask which documents jogged the witness's memory, there is a chance the documents will then be discoverable, depending on the witness's answer. Don't object to every question. That is an amateur mistake that a lot of people make. Think carefully about when to object. Form objections make sense when the opponent phrases a question in a misleading way, such as saying, "The FDA said your product was really bad. You see right here that the FDA wrote that your product was really bad, right?" Or rather, "You see right here that the FDA wrote that more than 1 in a million people suffer a serious side effect, right?" That is a misleading question, because it calls for making a value judgment about something somebody else said, and it's totally subjective, not a fact at all. Don't object to questions that are compound, vague, ambiguous, or otherwise flawed in a way that would actually make the question useless at trial, because even asking those questions is a mistake by opposing counsel. Instruct the witness not to answer when the question asks for information that is privileged, constitutes confidential information or trade secrets, or is entirely inappropriate, such as, "When did you stop beating your wife?" All you have to say is, "Objection, attorney-client privilege." Turn to the witness and say, "Please do not answer that question." That is enough. Or, objection, inappropriate, something like that. The questioner may ask appropriate follow-up questions to determine whether the privilege really applies, but by objecting, you've done your job. In videotaped depositions, try to position your witness facing the camera. Jurors like when they feel like people are looking at them. Try to avoid having the witness respond with simple, "I do not recall" statements over and over, since footage can now be edited so as to show all the "I do not recall" statements over and over, in combination, which can look really bad for you. Looks like the witness is lying. Instead, have the witness give more details. "Oh, that happened 6 years ago. I really can't remember what I said. I go to lots of meetings. It's hard to keep track, and I don't recall what was said." That makes it seem more real. Most people are aware that they can't remember that well for a significant period of time following something that's happened, and they'll understand. I hope you liked this, and if you did, I hope you tune in next week for how to take depositions, according to the Curmudgeon's Guide to Practicing Law. Till next time, have a good one.